Good afternoon to everyone in and around the courtroom. Madam Registrar, would you please call the case?
Good afternoon, Your Honours. This is case number IT 0484R77.1S, the prosecutor versus Shevket Kabashi.
Thank you, Madam Registrar. Yes. Could I have the appearances? Prosecution first.
Good afternoon, Your Honours. Joanna Corner, assisted by Alma Imamovic Ivanov this afternoon.
Yes, and for the Kabashi defense.
Good afternoon, Mr. President. Good afternoon, Your Honours. Michael Carnavas on behalf of Mr. Kabashi.
Yes, and Mr. Kabashi is present as well. We heard this morning the guilty plea entered by Mr. Kabashi, and the usual follow-up is that the Chamber will consider whether or not all the conditions are met for a finding of guilt. We do not at this moment proceed with that, and I'd like to give an opportunity to Judge Bonotto first to address a matter he would like to address.
Good afternoon to everybody in and around the courtroom. I confirm what Judge Ore has just mentioned, that we did hear the intentions of the parties for this afternoon. That notwithstanding, I would like to say something about how I feel about my participation in this trial. Under Rule 15A of the Tribunal's Rules of Procedure and Evidence, a judge may not sit on a trial in any case concerning which he has or has had any association which might affect his impartiality. In such circumstances, the judge shall withdraw from the case. I'm presently sitting on the Haradinaj et al. Retrial, which recently commenced. Earlier this week, Mr. Kabashi appeared before the Chamber in that case for the purposes of giving testimony. This has given rise to litigation between the parties, and the matter is pending before that Chamber. Considering my involvement in the Haradinaj et al. Retrial and the recent developments surrounding Mr. Kabashi's appearance in that case, I consider it appropriate to withdraw from the present case under Rule 15A, which I hereby do. I believe that it is not only a question of actual impartiality, it is also a question of the appearance of impartiality. As they say, justice must not only be done, it must be seen to be done. So I ask to recuse myself, notwithstanding no application by the parties.
Then Judge Davra would like to address a matter I think similar to the one addressed by Judge Bonotto. Judge Davra.
Thank you. Good afternoon to everyone in and around the courtroom. Indeed, more or less similar address. I'm sitting on the Haradinaj retrial, which recently commenced. Earlier this week, Mr. Kabashi appeared before the Chamber in that case for the purposes of giving testimony. This has given rise to litigation between the parties, and the matter is pending before that Chamber. Considering my involvement in the Haradinaj retrial and the recent developments surrounding Mr. Kabashi's appearance in that case, my concern is the integrity and the swift progression of the Haradinaj retrial. Therefore, I consider it inappropriate to sit in the present case and ask to be replaced. This concludes my statement. Thank you.
Thank you, Judge Davra. As matters stand now, we cannot proceed under Rule 62 bis. What we have to wait for is for the President assigning other judges to the case under Rule 15. I would like to add to this the following. This morning I said that I spoke for myself, which I did. I might have been a bit more reserved in exploring the possibilities of hearing the case. Would I have known already the position as expressed by my colleagues at this moment? They were in court. We hardly had time to communicate, but perhaps I should have been more cautious in already exploring with the parties what the possible follow-up would be. I apologize if that has created expectations which do not become true. At the same time, still being presiding judge over this case, I will try to make this case be heard as expeditiously as possible, and will keep the parties fully informed about any development. Mr. Kabashi, this may be a bit unexpected for you, but the situation is as it is at this moment. It also means that the detention order stands. We'll see how we further proceed, and as I said, and I again emphasize this to you as well, we'll try to proceed as expeditiously as possible. That's in the interest of justice. Are there any other matters the parties would like to raise at this moment?
I do wish to be heard because this matter was brought up yesterday, and it is disappointing that we were not informed because something might have been able to happen as far as getting to other judges, although I do realize the judge's position, and I commend them for taking that stance and perhaps having slept over the night about it and thought about it, they came to this conclusion. Mr. Kabashi has a 4-week child. He came here with the expectation of testifying to the extent that he was capable of doing so, and then hopefully dealing with this matter and then leaving. Needless to say, I am shocked and disappointed that we will not be able to proceed today. I realize it's not your fault. I'm scheduled to be in Cambodia tomorrow because I have other matters as well. So everyone has schedules. I don't know how long it will take for the President to decide when he will be able to find other judges to sit. It does cause a tremendous amount of stress because Mr. Kabashi is on suicide watch. Every 30 minutes he's being woken up. He hasn't slept since he's been in there. He hasn't been able to purchase food because for some reason they messed up on his slips. He spent 3.5 years in a prison where he was tortured on a repeated basis. And now here we find ourselves in a situation where somebody, a witness, is trying to do the right thing, and now I feel personally responsible for convincing him to come here, as opposed to fighting it in New York and not coming here. I apologize for raising my voice. I know my client is extremely hurt by what has happened right now, and perhaps my anger is in some way comforting to him, although I know it's a displeasure to the trial chamber. If there is any way of knowing when we could proceed, because frankly, had I known we would be in this position, perhaps we would not have a guilty plea this morning.
Mr. Carnevas, I'd like to add a few words. First of all, the expectations Mr. Kabashi may have had when he came to the Netherlands were his expectations. Second, developments in a case which I did not witness but which were witnessed by my colleagues are developments for which this chamber, including my two colleagues, are not responsible. You may have noticed that and I think my colleagues as well, have been willing to see how we could, as expeditiously as possible, deal with this matter. At the same time, every judge has his personal responsibility whether or not to recuse himself. The judges made themselves available for this afternoon. There was no reasonable expectation that my colleagues would refrain from following their conscience as they did this afternoon. I fully understand that it may be a disappointing development. At the same time, the tribunal is also not responsible for the 3 years that elapsed since Mr. Kabashi left the premises then of this tribunal. I'd like to have this very clear on the record. We adjourn, and of course you will be informed as good as possible about any follow-up of the present situation. Ms. Corner, although you have not indicated that you would like to add something, I think I asked the parties, but I would have to check that. Is there anything you would like to raise at this moment?
No, thank you very much, Your Honours.
Thank you. Then this concludes this hearing. We'll adjourn sine die.
All rise. Veuillez vous lever.